Right, welcome everyone, and thank you for joining Greenway's Super Series. This seminar is on reconsidering final orders, both parenting and property in the family law context. My name is Josh Knuckstret. I'm a barrister at Greenway Chambers. I practice in commercial and family matters, and I've been at the bar for around 17 years. I'll be presenting together with Leah Reid, also a barrister at Greenway Chambers, who practices primarily in family law, and she's been at the bar for almost 6 years. Just to kick off our discussion, it's useful, I think, to set a bit of context when we're talking about reconsidering final orders, because the word final has a particular meaning which would rather suggest that reconsidering might not be a possibility. And of course, the principle of finality has a long history in our system of justice. It's been recognised in many cases, and on this slide we've provided a quote from a seminal High Court case on advocates' immunity, where the High Court said that finality is a central and pervading tenet of the system, and one should not be reopening cases except in narrow defined circumstances. That principle is expressed in various forms in the law. Those forms include res judicata, where rights merge in a judgment. They include ancien estoppel, which essentially provides that where an issue should and could have been raised in proceedings but was not, then as between the parties to those proceedings, they will each be estopped from raising that issue in future proceedings. It comes up in the doctrine of abuse of process, which is a really broad concept which can be moulded to suit many different circumstances and prevent, for example, repeated applications for the same sort of relief. And it comes up obviously in the context of, as I've mentioned, advocates' immunity, but also other immunities like witness immunities and judicial immunities. In family law matters, there is statutory recognition of the principle of finality. In the context of property matters, that's to be found in Section 81 for marriages and Section 90 ST for de facto relationships. And in parenting matters, there's also a statutory principle of finality embodied in Section 65D AAA, although it's slightly different and perhaps not quite as strict, as Leah will discuss. As with all good rules, it's not an absolute rule. And in fact, there are quite a few circumstances where finality gives way to other considerations. One obvious one is where there is an interlocutory order, and in circumstances where the interlocutory order finally determines certain rights of the parties, then it can still be reopened where there's been a material change in circumstances. That's I provided a reference to a case which is not a family law case, but that's sort of a principle of general application. Then where the interlocutory dispute does not finally determine the rights of the parties, there's a less demanding interests of justice test. Of course, there are the rule-based powers to set aside orders and judgments, which might include where an order is made in the absence of a party, or where there's been fraud, where the application to set aside is made by consent, and of course the slip rule. And then another obvious one, an appeal or a review right. That is obviously an exception to the principle of finality. And then lastly, there are specific statutory exceptions, and that is what we are going to be discussing today, starting with Leah talking about the exception in parenting matters.
Thanks, Josh. So the first thing is with parenting matters, there has long been a legislative power to vary the orders. It's specifically in section 65D, subsection 2, the power to discharge, vary, suspend, revive an earlier order. That's not limited to interim orders, that power. That power is also able to be exercised in relation to final orders. And notably, when you look at what the definition of a parenting order is, it sets out various different things. So, for example, it could be about parental responsibility or about time with a parent. But it also says, this is 64B, that an order discharging, varying, suspending or reviving a parenting order is itself a parenting order. Importantly, historically, if you've made an application under what was known as Rice and Asplund and it was dismissed, then that was not a parenting order. But as I'm going to touch on, there's a little bit of ambiguity about whether or not that is still the case under 65D AAA. Now, the logic of this, why should you be able to particularly consider whether or not we relitigate for parenting matters? Well, it's pretty simple. Things change, kids' needs change, and the law needs to be able to reflect that. And that if there's been a change in circumstances and the child's best interests have changed, if there's fresh allegations of harm, for example, the court shouldn't just ignore that because there's already been a trial. So I wanted to have a look at the history of particularly important cases. These are obviously not all of them, but the history since Rice and Asplund, which is obviously the seminal case that gave the name to the application. And even pre-Rice and Asplund, there was a full court decision of Hayman. So I don't know why we haven't been calling it a Hayman application, but for years we've obviously been using Rice and Asplund. Now, the facts of Rice and Asplund, for those that go and reread it, are wild. Like, they're wild in modern day times. So effectively, it was a matter pre-1975, and so pre-no-fault divorce coming in. And the mother and father had broken up. The father had unilaterally taken the kid, and the New South Wales Supreme Court eventually awarded him with custody, as it was known back then. The reason that the Supreme Court judge determined that the father should have custody was because the mother was of, quote, poor morality and low intelligence. Now, my understanding of the poor morality is because she entered into a extramarital relationship with a man called Mr. Asplund, who she later then marries, hence becoming Mrs. Asplund. She doesn't put him on affidavit at the time. And so a couple of years later, once no-fault divorce is actually introduced, she divorces Mr. Rice, marries Mr. Asplund, becomes Mrs. Asplund, and seeks orders in relation to the child. And the family court determines that remarriage alone was sufficient to reconsider what should happen to this child, and they determined that the custody of the child should be reversed. So the kid has been living with dad for about 2 years at this point and spending time with mum. Kid gets moved again to living with mum, and partly that was done on the basis that apparently Mr. Asplund would be a very good stepfather. The court decided he seemed like a man that was, of good character. And the wife undertook that she was going to give up her employment to look after the child. So in today's world, those facts seem absolutely wild, but this is obviously the case that gives its name to what we saw as the application to make a change for parenting orders. And the key thing, this is Evatt's decision, the Chief Justice, where Her Honour says that the court would need to be satisfied by the applicant there's some change circumstance which will justify a serious step, some new factor arising, or at any rate some factor which was not disclosed at the previous hearing, which would have been material. And so historically there has actually been a paper that was done by a particular academic who looked at when reconsiderations have been successful, and it's traditionally been things like fresh allegations of harm or a proposed relocation. So mum and dad separate, the kids are doing equal time, mum remarries, new husband is pregnant to new husband, and new husband gets a job overseas. That's the kind of case where obviously equal time isn't going to work anymore and we need to consider afresh. So some of these other cases since Rice and Asplund that are important have expressed the test slightly differently, and so that's why I've included them. So SPS is a Justice Warnick decision sitting as the full court, and unsurprisingly it's then endorsed by in Miller and Harrington, which, guess what, one of the members was Justice Warnick in that as well, with Boland and Murphy. So they express the test as assuming the evidence of the applicant is accepted, is there sufficient change of circumstances shown to justify embarking on a hearing? And they specifically say that it could be done either in a preliminary way or at the end of a full hearing. Now, for my part, I've never really understood the end of a full hearing, because if you've embarked on a hearing, then the child hasn't really been shielded from more litigation. In fact, they've been engaged in more litigation if they've, for example, had to go and see a family report writer, or if they've had an ICL that they've had to meet. Marsden and Winch came along in 2009. Now, the facts about Marsden and Winch are equally wild. So for those that don't know, Marsden and Winch is a case you might have heard of in various different areas. For example, in vexatious litigants, there's an order about the particular husband in that case. So the facts basically are the husband and wife break up. The husband has very unusual sexual proclivities, such that he ends up forming an inappropriate relationship with a 14-year-old neighbour and stealing her underwear. He's also very keen on going to the public pool and relieving himself, shall we say. So he's an interesting character, and unsurprisingly, the court said he should have no time with his very young child. He brought 3 different Rice and Asplund applications. This is the full court's decision on the first one, but there are a number of Marsdens and Winches if you want to keep reading through the whole sordid history of them. But effectively, the full court in this case say that they express the case as the test as being, is there been a prima facie case of changed circumstances, and a consideration of whether or not that is sufficient to justify embarking on a hearing. So they say it's two steps. Firstly, has there actually been a change? Make some findings about that. Secondly, is the change strong enough to bother embarking on a hearing? And that would take into account, for example, if the detriment to the child is going to be outweighed by the benefits. Now, DeFree and Radnor is a similar kind of case a couple of years later. They express it slightly differently. That this is a full court which say, having regard to the best interest of the child, new events or changed circumstances have to be sufficient to provoke a new inquiry. And the other one that I had back here, Baseman and Cartmill, is a really interesting decision of Justice Tree. His Honour goes through the whole history of cases about Rice and Asplund and distills down, as His Honour was known to do, distills down a really neat list of all of the principles from those. So I really recommend having a read of that if you're interested in the history. So, why do you care about the history if there is a whole new section? Because the history informs why the section was actually even created. So section 65D AAA, I haven't put the entirety of the section up here. I've just put on subsection 1. The first thing to note is that it's not a section which looks at when the court will make a change to an order. In fact, what it's about is about whether or not it would reconsider making a change. There's a slight difference between those two things. This was introduced as part of the May 2024 amendments, which also made an amendment to section 60cc and removed as one of the factors 3L, which was about the whether or not the court should consider, or it was mandated to consider rather, whether it was desirable to make orders that were least likely to lead to the institution of further proceedings. So that was in some ways, at that stage, a manifestation of the finality principle, and that's now been removed. There's really no talk yet in any of the case law that I've seen about the impact of that. Now, why has this been introduced? It came out of an ALRC report, and effectively it said that parents, particularly self-represented litigants, aren't going to know about this rule. And given how high the number of self-represented litigants are in family law, they recommended that the statute be as clear as possible on its face. So that was the logic for why this section got introduced. And the explanatory memoranda is really clear. It says it's meant to codify Rice and Asplund. So where parenting orders are in place, the applicant must establish there's been a significant change of circumstances since making those orders before they can be reconsidered. That's the intent. But the question has always been, is that actually what the text of the statute says? Because it doesn't seem to say that. It doesn't say you need to have a positive finding of a significant change. So this has been the problem. And there's been a bit of debate about it. Given it's dealt with in a threshold way, it's unsurprising that even though the amendments came in May 2024, it's already sort of been considered. Because, as you can imagine, people put in their application, they have a threshold hearing, it gets determined, and then it's very quickly gone to the appeal court. So unlike some of the other amendments that came in May, it's useful that we've had some jurisprudence on this, but as you'll see, some of it's not very helpful, really. So the first one was the Justice Chanel decision of Carlisle and Graham. Now, His Honour, with great respect, doesn't really engage in very much analysis of the new section at all. In fact, he doesn't set it out. He doesn't go through what the text of it is and what the intent is in the explanatory memoranda. In fact, he says in one paragraph, basically, it's nothing new, it's just a codification, nothing to see here. Regime is a much more detailed analysis, and that was Justice Altobelli's decision. And His Honour goes through the section of the text, goes through the case law up to that point, and says, well, look, of course, the statutory intent might be one thing, but the words of the statute actually have to prevail. And His Honour said it would strain the text to actually require a positive finding of significant change of circumstances. One thing I think is quite interesting that Justice Altobelli says, which is I don't think that has actually been formally settled yet, is whether or not it's now a parenting order. Because as we can see, 65DAAA requires the court to look at the Section 60cc factors. If it's a parenting order, you might think, well, why do we care? Well, if it's a parenting order, do you have to go through mediation first? Do you have to get a 60I certificate? Those are kind of procedural things that you might be thinking of. At the moment, I don't think there's a clear answer on that. So I think if you've got a client that is considering bringing an application under 65DAAA, you might have to go through those steps first just to cover your bases, just in case. There was also this WA decision from Justice O'Brien who sort of lands in the middle. He effectively agrees with what Justice Altobelli says, that it may not necessarily, the text of the statute may not necessarily require a significant change, but he says it's a distinction without a difference. Now, the problem with that case is that, number one, the person that was making the application to change the orders was a mother who was self-represented when she filed the material and then didn't show up on the day. The senior counsel that appeared for the father went through the long, arduous history of that litigation and actually argued successfully that the application should be dismissed and then sought a harmful proceedings order because there'd been multiple applications along the way. So I guess what I'm saying is that it didn't seem like a hugely meritorious case in the context of the lengthy litigation in that one. So then we started getting some appeal decisions, and the first one is a Justice Aldridge decision, but it's not actually a decision about 65DAAA, so it was somewhat unhelpful in that regard. It's an appeal from a final order that was made where the kid is quite young, and the primary judge ended up making an order saying that they couldn't foresee what would be in the child's best interest past 2027, when the kid would be about 6. So on appeal, the father was arguing, the appellant father was saying, well, that puts a hurdle. If those are the only final orders, if I have to show a change in circumstance, that's going to be a real problem for me. And the respondent mother was saying, no, you don't have to do that. 65DAAA would not require a significant change in circumstance, so there's going to be no hurdle to the father if he then, after the age the child turns 6, then seeks further orders. And what Justice Aldridge says is, If 65DAAA does not require a finding that there's been a change in circumstances, it would be otiose and the whole section would be pointless. But then he says, I don't really have to come to a view about that. So then we get to Radecki. Radecki is actually a case about 65DAAA. And again, the facts, less wild, unfortunately, with this one. Parties marry 2012. They have their child in 2013. They break up very soon after in 2014. And then when the child is very young, when the child is 2 or 3 years old, final orders are made after an undefended hearing. Now, the original orders actually have a notation in them which contemplates an increase in time that when the child goes to school, the parties will go to some mediation and consider an increase in time for the father. The parents were actually pretty amicable for a very long time, and then their relationship as co-parents broke down and became dysfunctional around 2022. The mother says that's because of some alcohol issues, and the father says otherwise. But in any event, the father files a fresh application, July 2023. I don't know why it took so long from July to get to a threshold hearing on this, but it did. So the primary decision is by Judge Neville down in Canberra, and then it goes on appeal. And Austin and Williams, in their joint judgment, spend a significant amount of time going through the text of the statute, the explanatory memoranda, the second reading speech. They go through the history of the case law, and they say this, that it is a misconception to apply the text of 65DAAA so literally to only require a court to embark upon a consideration of whether or not there has been a change in circumstances, but without imposing an obligation to make a positive finding about that pivotal issue. And they say, if you would read the literal words, it would be absurd. So we're going to read them having in regard to the purpose of what was intended by Parliament. And Carew agrees, but says something slightly different. Her Honour says the use of the term consider in 65DAAA1 should be understood in the context of the court being asked to accept the applicant's evidence taken at its highest, but only for the purpose of the application. And then Her Honour goes on to talk about that if the court had to consider whether there had been a significant change without having any consequence, it would give no effect to 65DAAA1. So, what does the full court say the test is now? They say it's 2 stages. The first stage is, has there been a significant change in circumstances since making the final parenting orders? If the answer is no, that's the end of the matter. Goodbye. But if the answer is yes, then you move on to stage 2. And stage 2, they say, is in section 65DAAA 1B, which is it in the best interests of the children for the final parenting orders to be reconsidered? And you have to consider the section 60cc factors as well as the matters set out in 65DAAA 2, which looks at things like what were the reasons for the final orders being made. Importantly, this is not the same stage 2 as what it was in Rice and Asplund. So even though Rice and Asplund and the cases that came after it talked about a 2-stage test, remember that test was 1, what are the findings of fact about the changes? And 2, are those changes sufficient to embark on a new hearing? It did not require the section 60cc consideration, whereas now, pretty obviously in stage 2, it does. So why does that matter? Well, again, do you need an ICL for the child? Are they going to have to meet the ICL? Because remember, the ICL has now obligations to meet children who are old enough. Number 2, are you going to need a family report? Are you going to need some expert evidence? If the point of this section is to shield children from ongoing litigation, it seems a little bit unusual that this particular part requires you to deep dive into considerations that might need the child to be engaged in the litigation. Nevertheless, if the answer to this question at stage 2 is no, then again, that's the end of the matter. So even if there's been a significant change, if it's not in the child's best interest to re-embark on a hearing, then no luck. But if the answer is yes, then you would recommence the rehearing. So Radecki really says that we should read this first section, 65 DAAA subsection 1, as if the words considered whether had been crossed out and that there's a positive finding made. Now, my question is this. If the intent of Parliament was to do that, what's the purpose of these words in the second part of the section? Why would, if it required a significant change in circumstances, you wouldn't need to have those particular words in 1B. So it seems a little strange that the court, when considering the text of the statute, didn't read it as a whole, but I'm not a full court judge. The other thing to know about Radecki is that the appeal was only advanced on one ground, and that ground was that the primary judge erred in finding that there had not been a significant change in circumstance. That was the successful ground, and it wasn't argued before the full court that there'd been a wrong test applied and that the judge didn't actually need to find a significant change. So in that context, you could say that the full court's comments in Radecki are just obiter, in which case, if you're acting for a party that puts on a 65 DAAA application and it gets dismissed, you might consider on appeal arguing maybe Radecki's not binding, or you might consider arguing that it's plainly wrong and it'll be overturned, and then we can let the High Court or a different full court first, but then eventually the High Court determine the interpretation of the statute. But importantly, one thing you should realise about this is that, and in particularly in Radecki, you may need leave to appeal. Why do you need leave to appeal? It's an interlocutory decision. The dismissal of a 65 DAAA does not finally determine the rights of the parties, because a material change might come along further down the track and there might be a reason to actually reconsider the parenting orders. So with that said, I think that it might be difficult for a person to get over the leave to appeal to then argue, for example, that Radecki is wrong. So I think for the moment, we should assume that this two-stage test is the correct test and proceed accordingly. Now, turning over then to property matters, can I hand over to Josh, who's going to look at when you can reconsider under particular sections of 79A.
Thanks, Leah. So, the regime for reconsidering property orders is Section 79A for marriages and Section 90 SN for de facto relationships. This is obviously distinct from an appeal. Appeals relate to errors in a decision, whereas the focus of Section 79A is on things external to the original decision, or largely external to the original decision. There is a discretion under that provision. This clicker is not working. Oh, there we go. So there's a discretion to set aside, vary or substitute an order where one of the subsections has been satisfied, and there can obviously be overlap. The first is obviously miscarriage of justice, but not just any miscarriage of justice. It has to arise by reason of a number of different possible factors, including fraud, suppression of evidence, the giving of false evidence, or any other circumstance. But that is a miscarriage of justice by reason of any other circumstance. Then there's impracticability. There's default, and it is the longest subsection. So it's exceptional circumstances arising since the order was made, which relate to the care, welfare, and development of a child of the marriage, and give rise to hardship. And another subsection is where a proceeds of crime order has been made. Then there's an additional discretion where the parties consent. So this seminar doesn't really deal with subsection A, dealing with miscarriage of justice, because that's a huge topic. Most of the case law in this area is under that provision, and it would require really a seminar of its own. And in fact, there is another seminar on that topic in the Greenway Library, which Leah has done. So I won't go over that. With a paper, yes. But what's interesting about subsection A is that it's a bit of a hybrid in that the factors discussed in the statute focus attention upon the original proceedings. So just to remind you again, miscarriage of justice by reason of fraud, duress, suppression of evidence, etc. So the focus is on the original proceedings and something that went wrong in the original proceedings, but that is still external to the reasons for the judgment that was made. The other factors in section 79A1 are different because they focus upon completely external matters. And the first one of these that I'm going to talk about is impracticability. It requires two things only. First, that new circumstances have arisen since the original order, and secondly, that it is impracticable to carry out the order or part of the order. And that is a seemingly undemanding test, but the very limited case law in this area suggests otherwise. In Cawthorne, there was a very long marriage. There were consent orders made in 1992, shortly after the marriage dissolved. And under those consent orders, the husband was required to pay the wife $105,000, with $100,000 of that to be deferred. And the wife was to transfer a property to the husband once the payment was made. And there were some other additional provisions, obviously, but they were the main ones of interest. So the wife transferred the property and the husband had paid $5,000 but had neglected to pay the lion's share of what was due, the $100,000. The husband argued that it had become impracticable for him to comply with the original orders for two reasons. First, that the property that had been transferred by the wife was sold and the proceeds were less than had been anticipated. And secondly, that he'd suffered a fraud in his business by a business partner, and so his financial circumstances had declined. On appeal, the first part of that was abandoned and he just focused upon the fraud by the business partner. But one of the other interesting features was that a finding was made at first instance that he had continued to enjoy a high standard of living, including providing some money for his daughter's wedding of quite a significant amount, but had not made any payments to the wife. And the court essentially said that something like insolvency or financial problems are just part of the ordinary vicissitudes of life, and they are not enough. And in addition to that, the circumstances have to be beyond the party's control. There was discussion also about the need to come to the court with clean hands. So essentially, the court said that even though the wording of the section seems like it's quite open, it's to be construed really narrowly. And the court made reference to the doctrine of frustration in contract law as being analogous, although not quite on all fours with what was required by the section. So, in other words, at first glance, it looks undemanding, but in reality, quite a difficult test to satisfy. Because there isn't much case law on that provision, God, I'm really having no luck. There we go. This case, Sanger and Sanger, was a decision relating to an application to set aside a binding financial agreement, which has similar sort of wording in the statute to wording in section 79A 1C. And in that case, in the recitals of the binding financial agreement, there was a record that what the parties were trying to do was to achieve a 60-40 split in favour of I'll call her the wife, and to give effect to that, assets were to be transferred and monetised and so on. And there was also a private company in the asset pool which was given an agreed value. After the BFA was signed, the private company was put into voluntary liquidation by the husband, and he asserted it had no value, and in addition, some of the assets that were monetised again were realised for less than the value that had been expected. The court essentially said that, notwithstanding the general statement that what was intended was a 60-40 split, the actual operative provisions of the BFA allocated risk between the parties, and the parties had accepted the risks that were allocated to them. And so as a result of that, it wasn't necessarily impracticable. And the court set out what is really quite a useful encapsulation of the test, which is that there's a distinction between something that cannot be put into practice and something which can be put into practice but produces a different outcome to what was originally hoped or expected, with only the former falling within this particular exception of section 79A, or in that case 90K. And there was discussion about the fact that impracticable does not mean impossible, but it's really quite close. So moving on then to the next topic, that of default. So this section requires, first of all, a person to have defaulted in carrying out an order. Then new circumstances have arisen as a result of that default. So there's a causal nexus required there. And then in those circumstances, it's just and equitable to vary or set aside or substitute the order. And this really is perhaps the provision in section 79A1, which has the most scope for challenging the original orders, because it really is just regulated by what is just and equitable. So it's unnecessary to establish any particular extent of default. It's enough that there has been a default to engage the operation of the section. And as I've mentioned, there has to be a causal link between the default and the circumstances. But that's to be analysed in a practical and common sense way. So all right, so Cawthorne, the case which I referred to before in the context of impracticability, also discussed default, and the court in that case said, in relation to both of these subsections, that the default cannot be as a result of a party's own conduct in order to enliven the provision. It has to be really beyond their control. And as I've mentioned, ultimately, the gateway is what is just and equitable. So that case, Blackwell and Scott, again, there were consent orders made in that case. It was a de facto relationship, but a reasonably long one. It was about 10 years, and there were 2 children of the relationship when the original orders were made. And there, a 50-50 split was intended. The husband was intended to retain some property and pay the wife some cash. The husband retained the property, but he didn't pay the wife the cash. So it's a little bit like the other case that I mentioned before, he didn't pay the wife the cash for about 13 months. And in the meantime, the value of the property that he kept went up. So when the application was brought, the husband argued that the property value going up was not causally related to the default. So just remembering that there has to be a causal nexus between the default and the new circumstances. But the court disagreed and said, because the intention of the original orders was a 50-50 split, the default defeated the intention because by the time of the transfer, that intention was not going to be realised and there wouldn't be a 50-50 split. And this gets back to the idea that the causal link's to be determined in a common sense and practical way. And it can be contrasted with the BFA case of Sanger and Sanger that I mentioned before, where in that case, the court found that really the intention, despite the statement that the parties wanted to split their assets in a particular proportion, the real intention was to allocate risk, and the parties had agreed to do that, and ultimately the fact financial circumstances had changed was not enough. But here, because the court found that the intention was to achieve a particular split, that was enough to find the causal link here. And obviously, because we're talking about what is just and equitable, equitable concepts come into play, like clean hands and conscience. So, lastly, subsection D, the really wordy one. That one requires, again, new circumstances since the making of the original order. But in this case, the circumstances must be exceptional in nature. The exceptional circumstances must relate to the care, welfare, and development of a child of the marriage or relationship. And having regard to those circumstances, the child or the applicant carer of the child would suffer hardship if the order wasn't varied or set aside or substituted. What's interesting in this context, again, my clicker doesn't work, is that there's an unresolved constructional issue about who needs to demonstrate hardship. So in the paper which accompanies these slides, I don't know if you've been given it, but it'll be available after the presentation. There's some litigation, the matter of Garden and Gavin, which is discussed in the paper, where this issue came up. So in that case, there was an appeal where the full court held it was the applicant and not the child who must demonstrate hardship. And that really was just a throwaway line, not really something which was analysed. And in that case, I'll just give you the facts of that. So there were consent orders following a contested hearing, so a fully contested hearing, but then consent orders at the end of that. Money was to be paid by the wife to the husband, and the husband was to transfer a property to the wife with an overall split of 65% to the wife. It was intended the children would live with the wife and that the husband would have contact with them, but a really short time later, the children moved to live with the husband. So the husband filed an application to set aside the orders, and the court originally did vary the orders and essentially reversed the split so that the husband ended up with not quite, but almost 65%. Then there was an appeal, and on appeal, the court again talked about what the original intention of the Section 79 orders were. So the theme that seems to run through all of this is what the intention was behind the original orders. The court said it wasn't clear that they reflected the wife's caring responsibilities, and part of the problem was that they were consent orders, so it wasn't possible to tell what the intention was behind them. The court also said that the hardship that was being asserted related to the children and not to the applicant, and so the orders were set aside and then remitted. The case on remitter is also in the paper, and on remitter, the application by the husband was dismissed. So this was a complete reversal from the original outcome. Again, the court said the vicissitudes of life are not enough in this context, not enough to satisfy what is exceptional. The court found, interestingly, that children who essentially changed their living arrangements quite quickly after the original orders were made can give rise to a finding that the circumstances are exceptional in nature, but not in that case because there had always been fluidity in their living arrangements. And then the court said even if that's wrong, there wasn't hardship. In that case, the court said hardship could be demonstrated by the applicant or the child. So there was a slight difference of opinion there in that constructional issue, which, as far as I can tell, still hasn't been resolved. The bar on this section is really very high, and I've said there that even death sometimes does not suffice. So in that case, there was a blended family. The husband had a child from a previous relationship. The wife had a child from a previous relationship, and then they had their own child. There were consent orders under Section 79, but about a month or two later, the husband committed suicide. The court found that the death of the husband was an exceptional circumstance, you'll be pleased to know, so that does tick the box. But in that case, the case of public trustee in Gilbert, in that case, the court found that the element of hardship hadn't been demonstrated, and that was because the application related to the husband's first child, so that was the stepchild of the wife, and that child was not a child of the marriage, and the terms of the legislation say that the hardship has to be suffered by a child of the marriage. It seems like a pretty harsh black letter outcome, but when you look at the facts a little bit more closely, there's some analysis of how the death of the husband actually led to an increase in income for the wife for various reasons. The estate was left to that child to be vested when that child turned 21 and otherwise controlled by the public trustee until then. So it's perhaps not quite as harsh as it seems, but it really does demonstrate that even in circumstances like that, the bar really is very, very high. In terms of what an exceptional circumstance is, it has been held in various cases, including in the case of Baker and the Queen, which is not a family law case, it's a completely different context, but it's been held that they are circumstances which are out of the ordinary but don't need to be unprecedented. They just need to be something not routinely encountered. And that type of reasoning has been adopted in family law cases as well. And ultimately, whether there are exceptional circumstances is a matter of fact and degree, and that's demonstrated I suppose, by the case that I was referring to earlier of Garden and Gavin, where the court said sometimes children moving from one house to another can be an exceptional circumstance, but not in other cases. So that's that point again. The other point to make here is that the concept of hardship, it's been held, is to be determined in the same way as what an exceptional circumstance is. So that is, it doesn't need to be completely extraordinary, but it has to go beyond the ordinary vicissitudes of life. So lastly on this, if you get through one of these thresholds, that's not the end. It's still subject to the court's overriding discretion to actually make an order. So there's no prima facie entitlement to relief if, for example, you manage to demonstrate that it's impracticable for the order to be complied with. In the exercise of discretion, one of the factors is the principle of finality, so that's very important. It's been held that setting aside an order is an extreme step, and in terms of what the court will look at in exercising discretion, it's basically everything. The circumstances surrounding the making of the original orders, and the circumstances of the parties since the making of the original orders. Factors like delay and prejudice or hardship. When I say hardship here, I mean hardship in the sense of prejudice to the opposing party in having to relitigate the issue. They are relevant factors, but ultimately, in the exercise of discretion, it's the interests of justice which are paramount. Oops. So, just a little bit on practical considerations. As we've seen, it's an extremely high bar, especially in, and perhaps maybe exclusively in property matters. It sounds like it's a little less difficult in parenting matters because that's a much more fluid area. The principle of finality is given significant weight, and obviously it's necessary to be really careful about the way you prepare because the decision is discretionary. If you want to appeal, appeal grounds are limited to the types of things discussed in House and the King. So it's a limited set of errors that you can appeal on. So lastly, it seems like you can't do a CPD these days without discussing AI. So here is our mandatory slide on AI, and we've concluded that it has nothing to do with this topic, at least not yet. But we can make a couple of observations. One, it's probably inadvisable and it may well be unethical to generate your court documents using AI. The Supreme Court has issued a practice note essentially saying that you shouldn't do it, and that hasn't happened yet in the family law context. But
they've got a committee, is my understanding. The court has a committee to make a practice note about it.
The other point is don't get it to do research without checking, because it's often wrong and sometimes completely wrong.
Like overseas, it wasn't Australia, somewhere overseas, they found that ChatGPT was making up cases.
Makes up cases.
Putting two names together.
Yep. I've tried just for fun to use it a few times, and it will do things like make up a case name and make up the facts and what it says. It will put a real case name next to fake facts and a fake holding. It'll just do a complete mishmash, and you'll tell it it's wrong and it will agree it's wrong, and then it will give you more results which are also wrong. So eventually I imagine that will be ironed out, and we can see a future where that kind of thing will change, but for now probably best not to use it. Sorry. So I might hand it back over to, well, I'll sit down and we can both take questions.
We haven't got anything online.
Just to let you know, also the slides will be available in hard copy, or you can download them from the website, and there's the paper on the property matters as well. So
There's no questions online. Are there any questions in the room? If not, I think I just want to add one thing. Particularly on impracticability, if you have clients who are coming to you with proposed consent orders which require a sort of staged approach, you pay me $100,000 this year and then I wait a year and you pay me another $100,000, you pay me another $100,000. Number one to know is that the court might reject that. Even the registrars, the deputy registrars are handing out more and more requisitions, is my understanding. So they might reject it under the on the basis that it doesn't actually meet the finality principle. But number two, I would think that in your letter of advice, you should be advising them about the risks associated with that sort of long-term payment plan, if I can call it like that, and the fact that it may become impracticable or close to impracticable, but they may not be able to change it. They may not meet the high bar under 79A. So one way that you can get around that, for example, if there's a concern that the property will go up or go down, one thing that you can consider is building into the orders, if the house sells for this price, then it gets split in this particular way. If the house sells for more than this price, then it gets split in a slightly different way, and it might be that you get a percentage of that. And if it sells for less, then your client might want a dollar figure rather than actually a percentage amount. So you'll have to give some advice about the benefits and the risks of taking a dollar amount versus taking a percentage amount, and thinking about whether or not the property in particular could go sell for higher or lower. Because the last thing you want is your client's really happy with a deal that's 50-50, and then it turns out the property that's in the husband's name has just gotten DA approval and the developer's paying $10 million for it. And then you haven't given them proper advice about how to deal with that. So just be aware of that type of thing. That's my only comment in relation to that. And so unless there's any questions, then thanks so much for joining us.